Welcome to the Jersey Justice Podcast, featuring your hosts, attorneys Gerald Clark and Mark Morris.
All right, Evan. So we're on. Thanks for coming. So tell us what you do for a living, and why you're here. What we asked you to come in and talk about, which is this crazy arbitration clause stuff.
Happy to be here, and thanks for having me, guys. So I'm a personal injury attorney at Stark & Stark. I've been there for about 12 years now. Growing up, I always wanted to be a lawyer. My dad was a lawyer, and I always, was very intrigued by what he did. And I remember when I was, 2 or 3 years old, going into his law library, not too different from where we are here, and, playing around with his dictaphone and messing up his tapes that he had dictated on and, put my own stuff on there. So I sort of always knew that this is the direction I wanted to go to. My dad did some defense work for the first 15, 20 years of his career, which is great. He really enjoyed that. But his firm switched over and they did all plaintiffs work. So by the time I got there, they were pretty much a plaintiffs firm. So that's why I've represented plaintiffs my entire life.
What do you mean defense work? Like, what is that?
Insurance defense work, yeah. So before, the in-house counsel days, which we see a lot now, more insurance companies hired their own attorneys, and my dad worked with a couple insurance companies down in South Jersey. Ohio Casualty was the big one, and that got bought up by, I think, Peerless and now Liberty Mutual. And, so I remember towards the end of his defense career, they were criticizing a couple of his bills on cases he won them a lot of money on, and he just said, it's not worth it anymore.
So how does that work? How does insurance defense work for some of the people that listen that, aren't lawyers, aren't kind of in the personal injury area?
Yeah. So, we'll just take the typical example of a car accident. You rear-end somebody, you're making a mistake. You have insurance. The insurance company, they retain a lawyer for you to defend you. But the interesting thing is, who is really their client? Is it the person who did the wrongdoing, the person who rear-ended, or is it the insurance company, the one paying their bills? We could have a whole other podcast about that, about the ethical issues about that. And so, he was retained by insurance companies to defend people in civil litigation. And that's how I got involved in this whole.
So if you have a house, you have to have homeowners insurance, or if you drive a car in New Jersey, you have to have auto insurance. And basically, if you cause a crash or do something and you get sued, the insurance company then hires lawyers to represent you in the case, and then they pay any settlement or judgment up to the limits of the policy.
Correct. And, I think the big difference is there are some insurance companies that, really care about their insureds and they get really good lawyers to defend them. And then there's some insurance companies where my personal feeling is they don't really care about their insured, and they leave them out to dry, and they hire these people that literally graduated law school, a couple months ago and just passed the bar to defend their serious case.
And why? Why do they do that?
It's all about the money.
Yep.
All about the money.
And people should know to get good insurance, you could get as low as $15,000 in insurance coverage for auto, or you could get $50,000 or $100,000. But people should know that to get a good amount of insurance, like $500,000 or $1 million, it's actually not that much more expensive, and it protects you a lot more.
Yeah, that was a big thing that I realized once I started doing this, and really once I started being more successful, and I had more money to spend on insurance. And I remember going from an insurance policy from $500,000 to $1 million, and I think the difference was like $8 a month. And
Wow.
you double the amount of coverage you got. And by the way, when you call up the insurance company, you get that policy, they don't tell you, hey, get this extra coverage, it's only this little bit. They really make more money on the smaller coverages.
Yeah. So I used to spend a lot of time in New Mexico. We go surfing and stuff, and I would walk down a street in kind of like a major city, major tourist, and it would be, you'd walk on the sidewalk and it would be treacherous. There'd be just crazy drop-offs or holes, and it's super dark. And I always said to myself, I'm like, man, they need some personal injury lawyers here, because this is really dangerous. And then I asked around. I actually met with a lawyer down there, and I learned that they don't really have personal injury law there. They do and they don't. I think it's almost like criminal, or no one has insurance. But as a practical matter, there's no personal injury mechanism or setup. So people can't really file lawsuits. It's discouraged. And just take a simple thing like the sidewalks, they were like absolutely treacherous, you know? So can you tell us, like, what is this whole personal injury thing? Why does it matter? Like, what are rights that people have, you know, if they get shot at a movie theater because there's some mass shooter and there's no security, or someone's driving a car and they get crashed, or I was in an Uber the other night, probably like a week or two ago, and at one point the Uber driver was going 55 miles an hour or 45 miles an hour on the Parkway, the Garden State Parkway, and he kept like looking forward in his seat and back. And finally, I said to him, I'm like, bro, you're going 45 miles an hour on the Parkway. We're in a 65. He's like, oh, I can't see too well. And I was like, oh my, you know, sometimes I'm in those cars and I'm just like, I'm in the Uber and I'm like, just get me there, you know? And I've heard other crazy stories. Like a friend of ours goes to school at High Point in, I think it's North Carolina. And her and her two friends, or it was just her alone, got picked up by some totally sketchy Uber driver. It was like really sketchy. Thankfully, nothing happened, but he was, you know, speaking inappropriately. And, you know, you just had these visions of like a disaster happening. So what's the whole thing like with personal injury, recourse people have when disaster strikes, when just companies just are negligent or produce bad products? Like, how does that all fit into society, and how's it supposed to work without these ARB clauses?
So I had a really interesting experience in law school. I went to Rutgers Law School, and we had a summer abroad program.
Nice.
Yeah, and I was Rutgers Camden, so the Rutgers South, I guess. I know now it's under one name. And I had an opportunity to go to Europe for a summer and go to the International Criminal Court, and it was truly amazing. And in Amsterdam and The Hague. And when you get there, first of all, you know, my background, my dad's a PI lawyer, so, you know, I had always wanted to do this type of stuff. So people were very intrigued, like, oh, you can sue somebody for this? Like, why would you need to? And the question is, why would you need to? And there, you don't really need to, because when you get hurt, you go to the hospital and they pay for everything. You know, why do people come see us? Because they're hurt and they don't have money for treatment, or they can't navigate the insurance field. And so that's why they need our help. And so I think as personal injury attorneys, you know, we obviously we're in this business to help people, but we're also in this to make things safer. And when you look at a lot of the, you know, the regulations and rules, and, you know, I think in general in society, we don't want too many rules. You know, too many rules is not good, but we need to have certain minimum standards, and we need to have a mechanism to hold people accountable for those. And so I look at my firm, which has, you know, been around for over 100 years, and Albert Stark really grew the personal injury department at Stark & Stark. And one of the most amazing things that he did was he was involved in litigation with the rumble strips on the side of the road. And, you know, before we had those, you know, people were going off the side of the road and getting hurt, and these were horrible accidents. You know, we didn't have the level of airbags and, you know, safety that we do in cars now. Was much less safe at that time. And so they came up with this concept of we should put these rumble strips on the side. And, you know, fast forward, 50 years, I just resolved this case against the state of New Jersey involving a dangerous condition on public roadway, where they had resurfaced this road and they did not put the right edge on the road surface. And so a truck went off the side of the road, and there was a steep drop off there, and this truck went back on the side of the road, which is what happens when trucks go off. They automatically turn and overcorrect, and they came on to the other side of Route 29 in Hopewell, New Jersey, and they crushed our clients, and they died a miserable death. You know, one of the worst pictures I've ever seen in terms of the bodies. There was, you know, a fire that engulfed everything. The Mack truck, the fuel line underneath ripped open, and these people were crushed. My one client probably died close to impact, and the other one lived for a couple minutes, and he was a volunteer firefighter, and his own crew came to try to save him. Wow. And when they did, you know, when the police came, he said one thing, he said, "Shoot me." Oh, God. That's how bad it was. And so, you know, it was very meaningful for us to get the state of New Jersey to admit that this was not done properly, and this roadway edge was unsafe, and because of that, we are going to save lives. And so, you know, now that that's out there, I mean, any case involving a public entity, there's a public record. So, you know, that's what we do. We try to make these things not happen by making sure defendants, companies, all these people are held accountable for their actions.
Wow, that's a wild story.
Yeah.
We sit in here, we talk too. I mean, I think I had one question before, and I was like, "Oh, why do you hire, inexperienced attorneys?" You're like, "Oh, it's about the money." I think a lot of times the lens on personal injury attorneys are like, "Oh, it's all about the money." But here you're talking about a guy that's in basically a burning car, burning alive. Like, is that all about the money, or is that about kind of this, where Jersey justice? It's kind of system of justice.
And well, that's the beauty of being a personal injury attorney too. We get to pick the cases we want to work on, and there are
Yeah.
many cases that we have that obviously we pick because we're helping the clients, but we're going to make a significant fee on it. But there are so many cases that we pick that we're not going to make any money on this, but we believe in the cause, and it's an injustice, and so that's why we take it. I'm sure you guys don't take a lot of property damage claims, cars. No lawyers do that because there's no real money in that. It's a lot of time and effort. But recently, I had a friend call me up. Her friend in the community, they're from Nigeria. They were clearly being taken advantage of by this company, this insurance company, and it was a straight liability case. And they were claiming, the client said they were at fault, and they weren't, but they were taking advantage of the language stuff. And so we spent probably 25 hours on that file. We filed suit, but we did that. We didn't make any money off it, but it was wrong what this insurance company did. And so that's why I love being a personal injury attorney. I can take advantage of that. I can take those cases because really that person would never find somebody to hire to do that type of work.
Big time. It's fun. Even this past weekend, I was getting breakfast with family, and basically my brother-in-law, they had a car that was totaled, and he's a school teacher. His wife runs a dance studio, and that's meaningful for them. They're like, this car is worth this much. We're trying to figure out how do we get paid for it? Do we have to go out of pocket? And just given like 2 minutes of time to talk through that, let alone 25 hours filing a complaint, it goes a long way.
We got the body cam footage. We got everything. We, loss of use damages. We pulled out the whole 9 yards because really what they did is wrong, and the adjuster knew what they were doing.
So a lot of this like system of justice we talk about, the kind of end, I guess, result of it typically is you get to a jury trial, right? The idea is that you have a jury of your peers, assess your case, whether or not it's worthy of compensation, whether or not, what the defendant did was wrong. It didn't meet those minimum standards. But the case you're kind of here to talk about is something that went a different direction.
Yeah.
You want to explain that? Because you said the term before, arbitration. Like, what is that?
Well, first, before we get to arbitration, let's talk about what makes this system so great, and that's the jury trial. I mean, when you look at these other systems of law in other countries, they may have judges, they may have some concept of this, but nobody has what we have here, the American jury system. And I truly think it is the best system. And we've all had cases where we walk out of there and we say, they didn't get it right this time. But when you look at most of the cases that you've had, like overall, generally they get it right, the juries. And the system we have is pretty good. It's not perfect. And here in New Jersey, when you look at the Seventh Amendment, which is right to trial by jury, New Jersey, did you know New Jersey was the first one to pass the Seventh Amendment?
Wow.
Yeah. So, I always talk to, when I do my openings, when I tell them what this case is about, I always talk about it. I say, hey, down in Perth Amboy, I was in Middlesex last year trying a case. I said, 18 miles down the road, this was so important to New Jersey that we were the first state to get behind this, to pass this. And so when we look at arbitration is a process where you resolve cases outside of court. And I'm not here to say arbitration is a bad thing, because there are a lot of situations where arbitration is a good thing. When you're a sophisticated business and you might not want to go through 2 years of litigation and legal bills and everything, and you've got another business that is also a sophisticated business, and you make a knowing decision, we're going to go to arbitration, that makes sense. And, I think our courts are overloaded right now for a number of reasons. And so I think that there are some good reasons to go to arbitration, provided that both people have a choice. But what do I have here in this case with Uber is it's forced arbitration. And over the past decade, we've really seen more issues with forced arbitration. And, it could be a situation where, say, I don't know if you guys have kids. I've got a 9-year-old son. We're in the birthday party, realm right now, where every other week seems like we're going to some fun zone or wherever it is for the kid's birthday party. And, a lot of these trampoline parks, Urban Air, Bounce Zone, whatever they are, Sky Zone, to go in there, you've got to sign the arbitration agreement. And, my son, he started school during COVID. I was a kindergartner, and so I drove him to school every day. And so I was making phone calls and everything during that time. And so I was very proud because when my son was in first grade, the teacher told me that he told everyone in the class, my dad says don't sign the arbitration agreement. So, they're all talking about the party they're going to, and that's what my son told them all. So I felt pretty good about that.
That's funny because I was looking at, and obviously we're here to talk a lot about your case, but it looked like at least back in October of 2023, the state of the law in New Jersey on these arbitration agreements, it's kind of not settled. I know there's a policy that favors arbitration, but in the same sense, there's not a ton of published case law on the issue.
No, there's not. And there's also something to remember, too, and that's federal preemption with the Federal Arbitration Act, too. So what complicates some things we can do here in New Jersey. There is not a lot of settled law, and I think some of the, unpublished appellate division cases I've seen recently is sending us in a direction that I'm scared. This is not a good direction for consumers. And so my hope is, and we'll talk about my case a little bit more in general, but my hope is that the Supreme Court takes this case up because it's a very important issue that affects all of these people in New Jersey. And, New Jersey has always been known as sort of a pro-consumer state, and I don't know if that's going to be the same anymore if this continues.
Yeah, we talk about that. We do some consumer fraud work and, how favorable the law is to consumers in that respect and things, but yeah.
So talk why. So, but I don't understand. I mean, I understand, but for the listeners, why is arbitration a bad thing? I get it if you're companies and you want to limit stuff and you agree and you're knowing, but why is arbitration? Hey, we're not going to go to court. We're going to go to an arbitrator, and he or she's going to decide. Why is that different or less advantageous for consumers? And also, I'm reading. We had Alan Cantor on here recently, and he's kind of a well-known lawyer, and he got into this. He was first going to be a philosophy professor. He went to Harvard and all that, and I think he got a Harvard philosophy degree. And then it morphed into law, and he was talking a lot about normative philosophy. So I got a couple books on normative philosophy, and I've just started reading it. And one thing that jumped out in one of these books is it talks about how if you want to do something bad, you don't want anyone to know about it, and you want to keep it secret and all that. And so if you could talk a little bit about why the jury system and why, if you go to court, anyone in this can come into court and watch a trial, can watch a motion, can see what the court is doing, what the judge is doing. Why is that important to have a just and safe society that everyone knows what's happening?
Yeah. It's a great reason why jury trials are so important. That example I just gave you with the case against the state of New Jersey, if there was a non-disclosure agreement, or if we couldn't publicize that, well, people, what's their incentive for fixing things?
Sure.
So you've got to get these things out in the light to sort of cleanse them, to fix them, to fix the problem. And so with arbitration, number one, we don't get to pick the arbitrator. And so the people we're suing, they get to pick the judge because that's who decides these things. It's not a real judge.
If you have a mom and pop that got into an auto crash and they got to go to arbitration as opposed to, say, a big company like Uber, I'm sure Uber is sending a lot more business to this arbitration company and judges than just one person, maybe
millions
one or two.
And millions of dollars. And so let's think about this. The person deciding this case, if we are compelled to go to arbitration, is going to have a financial benefit from the people that picked them. And if they want to get picked again to continue arbitrating these cases, do you think they're going to give them a decision they're not going to be happy with?
It becomes like a defense expert or orthopedic expert.
Yeah, and the real reason I think Uber is and Lyft and these rideshare companies are really compelling the arbitration, because there are some cases where they're not compelling arbitration. I've had 20 cases before this where they haven't compelled arbitration.
I just said that to Jerry. I've had a number of cases as well where nothing.
Yeah, well, this is a bad case where my client is horrifically injured. Significant loss of income. She's an attorney, very successful family law attorney, but owned her own practice and didn't work for over a year.
So tell the story of the case. Tell us what happened.
So
and arbitrations, it's secret.
Yeah, arbitration is secret.
So whatever happened or whatever the decision is, it's not made public and no one knows.
And the big thing for these Uber cases, what they do not want to be found responsible for is they do not want to be considered the employee of the driver, because when they're considered the employee of the driver. Then you've got withholding issues, you got tax issues and Department of Labor issues. And so that's why they go to arbitration, because if they do somehow find a bad arbitrator that's going to rule against them, nobody's ever going to know about it.
So there was something in California about that. Am I making that up, where they're trying to...
So it's a little bit different in California. Those are the Uber drivers. So there's two angles of the Uber arbitration issue. There's the arbitration for consumers, so the people that download the app that want to ride. And then there's the drivers, which... this is their employment, and, they're trying to feed their families. And what a lot of these drivers have realized is, boy, Uber's making a lot of money here and the drivers are not. Yeah. And so, the question becomes, is Uber a technology company, or are they a transportation company? And Uber likes to say they're a technology company.
Yeah, because Jerry, the story you started to bring up before about, a family friend who's down at college and gets picked up sketchy Uber driver. God forbid something happens. Well, that does get then kind of dealt with in the dark. You've got one single arbitrator. Right. You don't have a jury of your peers where there's, here in New Jersey, 6 or 8 people, and open courtroom, people can come in. So what's the incentive to protect against that stuff? Yeah.
And we've gotten a lot of calls, not just about Uber, but other rideshare companies. And it's because the background checks are different. Like, let's look at a taxi company, like a true transportation company, a taxi cab. You got to fingerprint it. Like, they do a background check. Uber, they do the bare minimum. You have a pulse. Now, it's not that bare minimum, but it's close. And, to drive for Uber, you brought up the issue about the person who really couldn't see. There's no vision test or anything like that. They just see.
Clearly wasn't my driver last time.
Exactly. And the other thing, too, we've run into with many rideshare companies is somebody else downloads the app to be the driver, then they loan their car out to some other person who really should not be able to, would not be qualified. And Uber say, oh, we don't know about any of that. They know all of this stuff. They have so much, they're the technology company. God. They know how fast those drivers are. Yeah. When you get in an accident and the Uber driver that they claim is not their employee, but really is their employee, they can sense you're in an accident right away from the app.
I wouldn't be surprised if they're also can listen, and because buried in these terms and conditions,
sure.
There's probably something that says in legalese we can monitor what's going on in the car and listen.
Right.
I don't know that for
Well, they bury everything, and one of the things we'll talk about in a little bit is they get some language approved, and then they water it down, and they make it even harder for people to see what they're truly giving up. And it raises questions in my mind, at least. What is their motive here? And their motive is they want people to click on this and not look at all this and realize that they're giving away one of the most important things we have, our Seventh Amendment right.
All right, so go ahead. Tell the story of this case. What happened to these nice folks?
Yeah, so I think truthfully, we got to start a couple months before the accident. And January of 2020, my client Georgia McGinty. She is packing up for a ski trip with her daughter and her husband. And as you can imagine, if you're packing up stuff and you've got a 12-year-old kid who's hungry, going a little crazy. And so the daughter said, "I want to order food." And Georgia gives her the phone and says, "Okay, do the food order." And so that's where it starts. And so they make a food order through Uber Eats. And then a couple months later, 6 months down the road, my client, Georgia, and her husband are coming back from a dinner in South Brunswick area. And they call an Uber driver. And the Uber driver comes, and he's a little confused. We think he may not have even been able to operate in the geographic area he was, because he's a New York driver and he's in South Brunswick. Uber has a geographic field that they allow drivers to pick up rides, because they don't want someone driving 6 hours, being too tired and everything, because they can control all that. So in any event, the driver picks up my client. They're driving along, and he's going about 55 miles per hour. We have all this data. We did a download of the vehicle. We've got all of that data. And as he's approaching the light, my client is getting a little worried here. This guy's going pretty fast, and there's a red light here. They see it, and the guy is totally distracted by the app. We think because he doesn't know where he's going. He's not in the geographic area he's familiar with, and he blows through this red light at 55 miles an hour. And there is a van that is bringing about 5 or 6 people to a factory to work that evening. And our clients, the Uber driver hits that van. 2 people get ejected out of the van, and my clients are significantly injured. So John, her husband, has a very serious upper arm injury, hand injury, open reduction, internal fixation. He doesn't have full rotation of his wrist anymore. He used to be a big golfer. Can't do that as much anymore. But his wife, truly, Georgia, had the most significant injuries. The seatbelt almost cut her in half. It lacerated, went through all of her internal organs, and she developed this terrible hernia that looked like this 52-year-old woman was pregnant. And just the amount of trauma, and so she had to go up to the hospital special surgery to have surgery. She got an infection. She almost died on the table. And that's just the one injury. Then she had neck injuries. She has injury to her breasts. It's horrible. And some of the injuries that I don't even want to go into because they're so embarrassing for her. And it's truthfully one of the hardest cases I've had in terms of the injury, because a lot of times, people, they either die or they're, not as badly injured as she is. I mean, she probably should have died. She was 2 millimeters away from complete paralysis. She has a C2 hangman's fracture that they're just starting to work on now, 2.5 years later, because all the other stuff that she's been going on. We all have PIP in our personal autos. She didn't have any PIP coverage in this. Her health insurance, I think the medical bills are like $2 or $3 million.
Her health insurance was primary.
Yeah.
Not to cut your flow off, but just because, again, we always go back and forth. Sometimes lawyers are listening, potential jurors.
You never save anything doing that.
Yeah. So PIP is your personal injury protection. Through your auto policy, you have, they'll step in and pay a certain amount of your medical bills depending on what that is. But if your health insurance is primary, which again usually saves you a couple bucks, but in the long run costs you way more. If your health insurance is primary, that has to get paid back out of a lawsuit if there's a recovery.
Right, and it really saves the insurance company money.
Yeah,
that's really because they're not paying out on the PIP. And so my client also had an umbrella policy where she had, she's an attorney. She's smart, like she prepared, and that umbrella policy doesn't even apply because the Uber limits of 1.5 million for the driver don't trigger her UIM coverage on her own policy because there's 7 claimants. And so, so Uber, they say, oh, well, you can't sue us, but the driver has up to 1.5 million in coverage. Well, 1.5 million for 7 catastrophically injured people is nothing.
Wow.
Nothing.
So it's 1.5 combined single limit.
And so looking back, and I don't know if you guys were involved with any of the law when they made the TNC Act, the Transportation Network Company Act, but New Jersey did a good job at the time to lobby to get this law. And, we have trial lawyers to thank. It was NJJ and PAC and, a lot of people that really understood these issues. And Pennsylvania, for example, only has $1 million worth of coverage for the rideshare driver. New Jersey has 1.5 million. But Pennsylvania has better laws with stacking and everything. New Jersey doesn't. And so if we could go back, we really should have made that 1.5 million per passenger. That would have been the smart thing to do. And truthfully, they should have put in there something where you can't enforce an arbitration agreement. And so ultimately, I think we need to fix this TNC Act, which controls this, and that might be a possible legislative fix down the road.
And we operate in a world, too, where we throw around numbers like 1.5 million, and a layperson, just a regular person listening to this, is probably going like, 1.5 million? What do you mean that's not enough? But your client probably has hundreds of thousands of dollars in medical bills. Like you're saying, you got to split 1.5 among 7 people. That's not a lot of potential
The practice
recovery.
that she spent years creating, a solo practitioner, I mean, she had to close for a year, and you know what happens when you can't take new clients. Your firm suffers tremendously, and so her loss of income has been very significant. She's going to work less in her career without a doubt. There's no way she can continue to do this. Her husband too. I mean, the summer that this happened, they had to send their child away to relatives to take care of their kid because they couldn't even take care of their kids. So, 1.5 million divided by 7 is nothing.
Does under that act that they passed, the Transportation Act, is Uber allowed to be a defendant, or are they? What's the deal there? Because so people know ordinarily, if someone's hit by a FedEx truck, you would sue the driver, and then FedEx company would also be responsible because it's your employee or their employee. What's the situation with Uber? Is that undecided, or can you wrap Uber itself into the case?
So that really is an undecided area of the law right now. And what you're talking about is vicarious liability. The driver is responsible. I'm sorry, the employer is responsible for its employees' actions. provided that they're within the scope of its employment. So, the FedEx driver, that's a no-brainer. He's probably even wearing the FedEx uniform and everything. Now, Uber likes to say, oh, well, they're an independent contractor. And look, there are some that probably do fall under that independent contractor. They may work for Uber, Lyft, and Grubhub and all these other ones, I get that. But if it's one person who all they do is drive for Uber every day, they're an Uber employee. And the state of New Jersey Department of Labor agrees with me because they asserted a huge fine against Uber, hundreds of millions of dollars, and Uber settled that case, and we're trying to, we've subpoenaed the documents for that, Freedom of Information Act. We're still fighting to get those because how can Uber in the Department of Labor say, yes, these are our employees, we agree, and by the way, we're paying this huge, hundreds of millions of dollars of fine, yet in a court of law, we don't have judges who are holding them accountable and saying, yes, this is an employee.
And that's important in, for example, your case, because then you would have Uber's assets, which is going to have a lot more than 1.5 million in insurance, like the driver.
Yeah, and not only just their assets, but their coverage. Now, if you're in federal court, you get the true insurance declarations, and so we've had cases in federal court against rideshare companies, and they're very well insured, 200 million plus insured. So
wow. And that's just buried in there, kind of.
Yeah, and you don't get that unless you're in federal court, where they really, the magistrate judge is really, there's penalties if you don't listen to the judge there. Where state court, they sort of ignore the mandatory insurance requirement where they disclose the insurance limits.
So what was the kind of roadmap for your case? So this crash happens, you take the case on, you file a lawsuit with the idea, hey, trial by jury.
Yeah. And so the reason why my clients came to me in the first place is they know I handle a lot of Uber cases, and as I indicated, my client's a lawyer. She's got other colleagues that could have handled this, but this was a very serious case, and they wanted someone who really knew about the rideshare companies, and so that's why they came to us, because we've handled a lot of these cases. We've been very successful with them, but this case was different in that one, we let Uber know right away the significance of this case. I mean, we did a download of the vehicle right away. We participated in discovery. We gave them everything. We gave them all of our expert reports. And, we were operating under the assumption that they were going to treat the client fairly. Again, we've had multiple cases with Uber before where they haven't enforced the arbitration agreement. And so it came as a big surprise when we gave them all of our discovery, and I sent them a letter saying, hey, when are we going to depose the representative of Uber, because you're saying my client did all this stuff and we want this information. Then they said, boom, we're going to force the arbitration clause. I thought it was a little underhanded.
So just so people, so ordinarily you would file a case in court, you would go through a public litigation where anyone that wanted to know about it could go on. If there were hearings in court, anyone that was interested could come and sit in court and listen to the hearings and listen to the position that Uber's taking. And then if it went to trial, it would go to a public trial with about 7 or 8 jurors or so. Anyone could sit in there, and then the whole world would know about what the driver did wrong, or in another situation, if they have this issue with they're not checking people's eyesights, or if there's an allegation in a case that they're not doing significant background checks, then the whole world would know about it. And then a jury of their peers would decide what is fair compensation and whether or not they broke rules. So that's what you were expecting to happen.
That was what our expectation was. And, again, jury of our peers, that's the most important thing. And, by going through the arbitration process, we don't have that. And, I don't think you get a lot of attorneys bragging about the cases they resolved at arbitration. You don't hear about those that often, and probably a reason for that. But you do hear a lot about a lot of trial verdicts, because that's how things change. That's really how corporations are held accountable. And so by enforcing this arbitration clause on this very serious case, they have swept this under the rug. And, the resolution ultimately nobody's going to know about if we are stuck with this arbitration process. And we're also not even into, we've talked about the judge, we've talked about the arbitrator, all that stuff, but then let's talk about what are the rules. Yeah. So what are we entitled to? So, if we have a case in Superior Court out in the public, we've got a judge who, has gone through the process, has been nominated by the governor, has been vetted, has been practicing a certain amount of years, presumably has all this experience and all this power, because if the defendants don't give us something that they should give us, we can go to the judge and we can say, Judge, you should issue an order for this. We're entitled to this information, and we can get that. Arbitration, there's no guarantee that at all. It's whatever the arbitrator, the person that they chose to decide the case. They get to decide the rules. And in this case, it's very important because we don't know all this stuff they're trying to say, like, oh, your client clicked this time. We don't know any of that is actually true. We just have a certification. And so what other cases do you guys have where the defense can come in and win on a certification without doing any basic discovery? I mean, that should scare people.
So the arbitrator, with something like this, the arbitrator basically, gets to orchestrate. This is the discovery that, needs to be provided. This is, the discovery timeline we're going to do. That's how it works. The arbitrator becomes basically the master of the whole case.
And it depends. Most of the time, yes. There are some times where, let's say, both parties will agree, and then, they can be by consent. But how often do parties agree? That's why we have judges, because people can never agree on this stuff.
Yeah. So you said, I guess Uber then exercised their right or they, moved to compel arbitration. Right. How did they do that? Like, what did they do?
So they filed a motion in Superior Court. We had filed suit in Middlesex. That's where the accident happened. My client is a Mercer County resident. Middlesex, we all know, is great juries, and that's where the accident happened. So it made sense to file there. We were assigned to Judge Kaplan, who's a trial judge in Middlesex County, very distinguished jurist. He was a former prosecutor. Very high ratings from lawyers on both sides. Very well respected. And so we gave them all of our discovery, and then they filed this motion back in, I think, October of last year to enforce the arbitration clause. And we had a hearing. We fully briefed the issues. We had, honestly, probably one of the best oral arguments I've ever had before Judge Kaplan. I mean, and it was right after the pandemic, which was great because during the pandemic, we're all sitting behind our computers. I don't really feel like a lawyer doing that, That's why I wore a suit today, so I could feel like a lawyer. But, going back in and being in person, it was great. And Judge Kaplan, he knew the issues better than anybody. I mean, a lot of times, when the judge questions you, you're not sure how much they really read or how much they're knowledgeable about it. Judge Kaplan was the smartest guy in the room.
Yeah, and that's kind of his reputation as well. He's a great judge, smart guy. But it's funny, Jerry always kind of gives me a hard time or cracks up because I do my homework. And talking about the public, it being open, I pulled the transcript from that motion hearing. And we joke around. I had to tell the staff what I meant when I said this one time about like a hot bench, meaning the judge has a lot of questions and things. And here, certainly, but you could tell he was so informed. He had really thought through a lot of the issues. And, frankly, it seemed like he came to a very well-reasoned decision, as I'm sure you thought as well.
He had really done his research, and I was really impressed because he had actually gone through other cases, rideshare companies, to see what their terms and conditions were. So that's part of the game that these companies are playing, where they get terms and conditions that are approved and then they change them. And so it's a moving target. And so they like to say, oh, our terms and conditions were approved, but then they were different. And so he went through and he got those, and he got the agreements on all of them, and he synthesized them and looked, and it was really, really impressive.
And you talked, I know like a theme has been like keeping stuff in the dark, and I think you made a comment before as well, or maybe one of you guys did, that you'll get those terms out there that get approved and then you'll change them so that it makes them even more hidden. Anything like that with this case?
That's exactly what happened in this case. And so prior to our decision in the appellate division, there was another unreported appellate division case called Williams versus Isabel. I don't have the site in front of me, but it's an unpublished appellate division case. And Uber loves to say, oh, our terms and conditions were approved in that case. Well, the plaintiff's attorney in that case did not do what we would have done, which was dispute the conscionability of these terms. And so unconscionability was never an issue with Williams v. Isabel. And so there was also no discovery. The other thing, the lawyers agreed their clients clicked all this stuff. Totally different from our case. And so when you look at what we agreed and what we stipulated and what we were, what we were opposing, it was drastically different than the Williams case. But in the Williams case, the appellate division affirmed those terms, but then Uber changed the terms and they took out the stuff the appellate division in Williams v. Isabel said was significant, and they took it out in the terms and condition that George's daughter allegedly clicked in January of 2020.
To make them even more unfair to the consumer.
Exactly.
Yeah, and I'll share them. I think I've got them printed out here because it's funny. We talk like, lawyers, like words matter, but words really, really do matter, especially in contracts, things like this. But so it looks like back in January of 21, the terms were, you acknowledge and agree that you and Uber are each, and this is Judge Kaplan's opinion, he bolds this part, are each waiving the right to a trial by jury or to bring or to participate as a plaintiff or class member in any class, representative proceeding, all that. But the key thing there is you acknowledge, agree, you are waiving the right to a trial by jury. And then the new terms, and you can, obviously this is your case, you can tell me if I'm getting it wrong, but it looks like then the end of that year, December of 21, they changed those terms. And it says your relationship with Uber will be settled by binding individual arbitration between you and Uber and not in a court of law.
Right.
So what's the distinction there? What's meaningful about that, if
So,
anything?
Judge Kaplan, his opinion is pretty short, really well written. The thing that really sticks out to me is when he said, this court was neither presented or could find a published New Jersey opinion that upheld a consumer arbitration clause where neither the words waiver, jury, trial, statutory, constitutional rights were not included. We didn't have that in ours. And so that's why I was shocked when the appellate division, overturned Judge Kaplan, because he's right. And, it was just frustrating to go through this process. And, when we, so to go back on the timeline a little bit, Judge Kaplan reserved decision, which means he did not make his decision right away. He took about 2 to 3 weeks to write his opinion, which I think goes to show that this was not some, off-the-cuff decision. Like, it was a really thoughtful decision. He really wanted to make sure he got it right because he knew both sides were probably going to appeal from it. And so we won. We found out right in November, right around Thanksgiving, that we won. And then Uber decided to appeal that. They had an interlocutory appeal to the appellate division, and the appellate division heard argument. And then early September of this year, and then 8 days later, we got the opinion. I mean, that is the fastest decision I think I've ever heard of.
So
division.
real quick, you filed this public lawsuit, and then Uber filed a motion to essentially have the case, the public lawsuit, thrown out and say you have to go to this secret arbitration.
Yeah, and let me bring up 1.2 about the appellate division decision, which I think is really unfair and should really upset people. Those people that were going to work that day, the workers in the factory, they have to wait until our process and the arbitration process goes through. Okay. How is that fair?
And so that theoretically could deplete the combined single limit for your client and then leave left these guys to sort out.
But so these people that already, some of them didn't even pursue claims because, they were afraid if they did, they might be deported. I already feel bad enough for them about that. But then, they're horrifically injured. I mean, we're talking about spinal cord issues and everything. I mean, the people that were ejected were really, really hurt. And, they have to wait. Like, they never signed anything. Mm-hmm. Like, this is crazy. And Judge Kaplan never got to that issue, which is frustrating because I think he would have acknowledged that these people who never signed the agreement, why should they have to wait? Right. But the appellate division just, they said everything stayed until the arbitration's over. And that's really unfair.
It stayed, meaning it gets paused essentially until your case works.
So all these people, the medical bills, the interest continues to run. And this arbitration could be another year.
Yeah, justice delayed is justice denied.
Exactly, yeah.
But so if you're sitting here, Jerry has a son who's in law school. I have a buddy who's in law school right now. And I think back to like contracts. If you're sitting here listening to this and you're in a contracts class, like anticipate this could be on your final exam, the fact pattern to this case, because it's got all these juicy little contractual issues to spot that come up. Like number one, their daughter was the one that clicked the terms and conditions, and she's 12 years old, so she's a minor.
Correct. And so under the existing case law we had, minors cannot bind their parents to arbitration clauses generally, but the appellate division in this case said that when Georgia handed her phone to do the food order, she authorized her to enter into this arbitration.
So tell that story. We didn't talk about that here.
Yeah.
So I'm just be a little like kind of facetious here. So what happened? Your client, McGinty, as a lawyer, got a contract in the mail from Uber that had all kinds of instructions, and they bolded and highlighted all the terms, and she had like a big negotiation with Uber where she could kind of like go through and say, well, let's cross that out, let's add this and do that. And then she knowingly did that and decided, and then is that what happened here? I'm being facetious, obviously. like how did she?
Well, because that's what businesses have the opportunity to do. Right.
Right. So like how did it come that she waived her constitutional right to a trial by jury, and instead of having a fair system with a judge appointed by the governor, approved by the Senate, vetted, outside of politics, once they get on the bench, have to now get forced to this private forum where the arbitrator is probably doing, many, many millions of dollars of business with the companies through their, how did this all happen? This seems kind of crazy to me.
It was a pop-up on your phone, and we don't know how big the pop-up is. We don't know how long it lasted. We don't know any of that. All we know is they said at approximately, I think, 9:12 p.m. We didn't even know what time zone it is. That's unclear because we've asked for more information about that. They said somebody clicked this terms and conditions, which just says, I accept. So again, you don't have to read any of this stuff. This is called click wrap, and there's a whole bunch of body case law talking about clip wrap, text wrap, scroll wrap. Scroll wrap is when you've got to actually go scroll down to the bottom before you can go to the next thing. This isn't any of that. This is the basic of the basic, where it's on the screen. It says, here are the terms and conditions if you want to read them, or you can click yes or no. Now, if you click no, you don't access the services. You don't do anything. You don't get your Uber Eats or order. And if you click yes, you get your food, and everyone clicks yes. I have an Uber account on my phone. I click yes. I never really thought about that. I think, that's one issue. I think what's very distressing about this is this was an Uber Eats order, and then my client was in an Uber, a separate transaction, a separate app, really, a couple months later, and they're enforcing that arbitration clause.
And that's the story you were telling, where they were getting ready to go on a vacation. They're running around. The daughter's hungry, and the daughter says, hey, give me your phone. I'll order some food. The daughter apparently orders food.
Orders a pizza.
Goes through the necessary clicks to order the pizza. Yeah. They get in a horrific crash several months later, and they sorry, you're screwed because you clicked on.
It's like
how's any of that fair?
It's these infinite arbitration agreements, and you guys have probably seen recently about Disney, the Disney Plus issue, where this poor woman went to Disney. She was there with her family. She was allergic. She had a very severe milk allergy, dairy allergy. They go down to the Irish pub in Disney Springs, and they know about the fact that she has this dairy allergy. They check, and they say, oh, no, there's no dairy in the food. Well, they serve her dairy. And she doesn't just get sick. She dies. And she died as a result of their negligence. They knew she was unable to have any dairy. They had dairy in the food anyway. And the husband hires an attorney, and the attorney, presents the claim to Disney, and Disney says, whoa, pump the brakes here. 5 years ago, you downloaded and agreed to the Disney Plus app, and in the terms and conditions there, you agreed that any dispute between us would go to arbitration.
Oh, man.
Horrible.
So this is what's crazy to me. Okay, so like back in the day, when we were still ruled by the king, the soldiers would come in, they'd go to your house, the Quartering Act. They'd come arrest you. There'd be like a secret tribunal somewhere. You'd get flogged, thrown in prison, hanged, whatever it was. No fairness, nothing. And so we have a Revolutionary War, right? We have the War of 1812. All these people die, Fort Patrick Henry or whatever it was, where the Star-Spangled Banner was written. We go through World War I, World War II to protect these freedoms. After the Revolutionary War, they come up with a constitution. They say, we're not going to have these secret tribunals anymore. We're going to have jury by peers. Everyone's going to know. That's why if it goes south and it's unfair, at least everyone will know about it, and there can be. And all that is just puffed in the air by some stupid click wrap on a phone.
Yep.
And what's unfair about it these days is like I was listening to Elon Musk on Joe Rogan like a year or two ago, whatever. And he's talking about the Neuralink. Like, first of all, phones, like everyone's addicted to their phones, and it's like, well, let me go I'm not going to have a phone anymore, like, because I don't want to be addicted to it, Well, you can't operate in society if you don't have a phone. And then Elon Musk is talking about this Neuralink. He's like, well, the phone, it's just really it's a bandwidth issue. You don't really need the phone because we can just plant the chip in your head and then you can just think about it. And then your Amazon package will be here and all that. And I'm like getting fully scared, like listening to this. And then Mark Zuckerberg's talking about we're no longer going to live in a real world.
Metaverse.
We're going to live in this metaverse. and I'm like getting anxiety and sweating listening to all this because I think the phones enough are bad. And then Elon Musk on Joe Rogan, he's like, oh, well, you wouldn't have to get it if you don't want it. It'll be voluntary. That's like saying you can't get a phone anymore. Like I can voluntarily not get a phone. So it's kind of like Well, she didn't have to order the pizza on Uber. She could have driven to the store. Okay, maybe she could have today, but 5-10 years from now, are they even going to be a thing?
Well, when you look at Uber and rideshare, like one of the reasons why they're so popular is, our public transportation isn't as good. And so that kind of fills a hole there. And, I'm sure you have a lot of clients in cities, Jersey City, maybe Trenton, and they can't rely on public transportation to live. And so they're using Ubers. Some kids are going to school in an Uber. I have a client who had a very significant lung transplant, and she had to go to her follow-up visits. And she's using Uber for medical transports, and she's on Route 1, and her Uber driver rear-ended a tractor-trailer and caused a horrific accident, and obviously very significantly injured. But she's utilizing their services for follow-up medical treatment. I have another, my partner has a case involving a rideshare company where they're asserting the arbitration clause, and my clients or his clients don't speak English. They speak Spanish. And so guess what? The terms and conditions, all that, they're in English.
Wow.
And so, unfortunately, the judge said, well, you could use Google Translate. Well, is that what
copy and paste the terms into...
I think that's totally unrealistic.
But listen, I think this is why the legislature needs to step in here, or the Supreme Court needs to step in here, because... it's great Judge Kaplan looked at the documents and looked at it and said, well, they didn't have waiver to jury trial. This time they do. But all that stuff is a fiction because no one is reading that stuff. Your average consumer is not reading a 15-page small print document.
Scrolling on their phone?
Scroll. Yeah. And even if they do...
when you want a pizza.
Right. And even if they do, they don't really have a real life choice because of the pressures. You got to move. You need the food. You got to order. You got to... just like with a phone, it's not. It's just not fair.
It's very different than some of the earlier ones we talked about, where like the trampoline park. You don't have to go to the trampoline park, but do you need to use these rides? Some people do rely on these rideshare companies to live, and so they are a necessary part of our fabric, just the way we've evolved.
Like I'm a lawyer, right? And I actually read the stuff. I just had a company the other day to sell us some marketing stuff. And here's what they do, Mark. Like this is the thing. I've learned this. Like they must learn this at like sales seminars or whatever. You get a nice sales guy or gal, right? And they tell you this is great. I'm like, all right, well, let me see the document. Let me see the deal. Because I actually asked for the agreement. I want to see the terms and conditions. They give you a one-page simple, there's the price, there it is, right? I've had this happen before. And then once you're like, we're all good here, you've made this emotional commitment to it, you do it, then I give it to the staff to, okay, now go pay, and then they send you a link to pay. And when the link comes to pay, bam, that's where the clip wrap comes, which is those terms and conditions and stuff. And that's like a tactic they do. I had one with an alarm company. I wanted to get an alarm at my house, same thing. Sales guy comes over, he gives me a document, which is a simple 1 or 2 pager. Oh, this seems good, fair. We're all good here. And then, and then like right when we're about to pay or do the thing or consummate the deal, I thought I already did consummate, I signed it and whatever. They then give you this like 15-page terms and conditions. And me, again, lawyer, law school, 20 plus years of experience, I actually know what this stuff means. And I read it. And so this is an alarm company that is putting an alarm on your house to prevent, disaster from happening. And the document says, I read it, like buried on page 5 somewhere, it says, if we screw up and, the alarm doesn't work and your whole family's murdered, all we have to pay is the amount of the bill for the alarm that month, which was God knows what it was. Right. Like really unfair stuff. Like they're trying to turn us into like Mexico with I was saying with the sidewalks. Like the sidewalks are all, because there's no personal injury law anymore. There's no, and it just seems to me like another example of this crazy corporate unfairness that's out there. You know, and you can't have, you can't have courts and judges and stuff that are, arbitrators where they're saying, sorry. Like I think. Like I was saying, I think the terms and conditions, it's good that we kind of went into that and, you found the nuances in the documents, but it's all a fiction because no one's reading that stuff anyway. Yeah. And even if they could read it, and when I check these terms and conditions and like question people, the salespeople, they look at me, they don't even know what it means because it's been written by lawyers at corporate, you know?
They just tell them, you need to get this in.
Yeah. So I think the bigger problem is like this is why the Supreme Court I think should step in here, because there's a bigger issue here in terms of, because if Judge Kaplan says, well, you need to have trial and these are the words, they're just going to put it in there next
Big
time.
time.
And there is not going to be a single person who is not going to click on that and order their Uber because
it's funny. I was thinking that reading through it, it's like even if you win like the battle on some of these terms, then the greater war, it's just going to lead the defendants, the companies to tighten up those arbitration clauses. But it's one of the articles, I think it was the Law Journal. They say, there's a quote like, by handing the iPhone to their daughter, plaintiffs handed their 21st century pen to her. And it's the truth. Could you imagine if in like the 90s or the 80s or something, you order a pizza and the pizza guy comes, or they fax over this, 15-page agreement, and the guy's standing there with the agreement, like, all right, read this, sign. Right. And if you don't sign it, then you don't get the pizza.
So, talk about giving your kids the phone and everything like that. So my son, who's 9 years old, like, he snuck into my room over the weekend when I was asleep, and, he gets up at 6 o'clock on Saturday. I'm not getting up at 6 o'clock. I'd like to sleep till 7:30. And he took my phone. You know what he did? And my phone's got all security on there and everything like that. He found out a way to access it, because guess what he did? Held it up to my face when I was asleep. Yeah.
Ordered a video game or something.
Guess what he did? Bought $60 worth of Minecraft books. Wow. I didn't even know you could spend $60 on Minecraft books, but he managed to do it, and I authorized that sleeping when he went up to my face and did that. So let's do away with this legal fiction of, my client authorized her daughter to enter into the arbitration agreement. As I said to the Law Journal respectfully, that's insane.
Yeah. Let's take a. All right, cool. So Evan, back on. So what exactly is happening with the Supreme Court? Like, what are your kind of arguments as to what the Appellate Division did wrong, and why this is an important kind of public policy thing that the Supreme Court should get involved in?
Yeah. So first, for the non-lawyers listening to this, like, not every case can go to the Supreme Court. There's got to be a certain path for that. And in the Appellate Division, because it was a unanimous decision against us, there was no dissent. We don't have that automatic right to the Supreme Court. So we have to file a petition, which we've done for certification. And we're now doing the briefing, which will hopefully be done at the end of this week, for the Supreme Court to decide, do they want to take this case on? Is it of enough public importance that affects millions of consumers that I think it does here in New Jersey? But ultimately, our audience right now is the Supreme Court clerks, because they're the ones who are going to be helping the justices decide what cases to take.
Was the opinion published, the appellate opinion?
It was not. It was an unpublished opinion, so technically it's not binding. But in this day and age, with everything being on the internet, before it was a lot harder to find unpublished opinions. Like, I've been practicing 15 years now. Before, I'd have to go to the Rutgers Law Library and look them up, and or find someone who kept a copy of it. Now you just go on Google and you can find them. So a little bit different, but technically it's non-binding, it's non-presidential. And interestingly, Judge Kaplan's decision, the trial level decision, was followed by a number of other judges around the state. So that's why it was so surprising with the Appellate Division that they overturned it, because generally other judges looked at it and said, boy, this was pretty good. And they were following it as well.
But it's unpublished, but Uber is definitely using the unpublished opinions. Sure. In fact, you said earlier that other opinion, they're saying, look, these terms were approved using the unpublished opinions.
Yeah, so they got the upper hand at the appellate level, and they are sharing this with all of their lawyers, as you would expect them to do. The other unfortunate thing, too, we haven't talked a lot about this, but I think it's important to bring up, is like Uber can decide what cases they want to selectively arbitrate and not, which raises a lot of questions, because maybe they've decided a certain economic status or a status. If they're poor people, inner city people, they're gonna enforce the arbitration clause, or maybe it's based upon race or something else. Like, we don't know, but it's scary that they have that ability to selectively decide what cases do they want to arbitrate.
So you said you have something pending to the Supreme Court to see if they'll take this case?
Correct.
And what's the criteria for that?
Well, we've got to show them that it's of significant public importance to the state of New Jersey, because obviously there are a lot of, and I wish I knew how many cases applied for certification. I don't know off the top of my head, but most of them do not get certification. The Supreme Court only takes a certain amount. So we hope to be one of those cases where they take a look at this.
And you may have kind of answered the question I'm about to ask before and talked about this, but why is this such an important case for the public and, New Jersey.
So, think about all the times you go on the rideshare app. It might be Uber Eats too, as well. I mean, they're literally, I think we can safely say it's millions of people a day are doing this around the country. And, here in New Jersey, unless the Supreme Court takes this up, what Uber has done at the appellate level is going to stand.
And it seems like this issue has kind of caught fire too. It's not like Jerry and I sit around and monitor every decision that's coming down in, Middlesex County or throughout New Jersey. But, it looks like the press got a hold of it, and the Law Journal, even the New York Times had an article about this.
Yeah, the press has been really amazing, the outreach. When the decision came out the very next day, we got phone calls right away. There was somebody from Bloomberg had called up, and I guess, as you might expect, people in the media, they are monitoring different cases, and they saw this, and they reached out right away. They said, boy, this is kind of unusual. Really reminds me of the Disney situation. Can you talk about it? And so, Bloomberg had reached out to us. We did a little interview with them. And then the BBC reached out to us, and the gentleman who wrote that article about the McGinty case had also been involved in the Disney case as well. He had written an article about that, so he really knew a lot of those issues. And when the BBC article went out, that's when the match was lit. And we probably had over 100 different press inquiries from around the country reach out to us, which was amazing. And it was very fast. It was NBC, ABC, CBS, Inside Edition, Jersey Justice, of course.
Panda the sign.
Yes,
Panda
yes.
the sign.
I did say yes to you two first, by the way, Jerry, before the New York Times. But, I think it goes to show how important this issue is. I mean, obviously, the press isn't just writing about this stuff. They're doing it because, people are interested in it. And it's getting people upset. Not only are they interested in it, but there's, the fundamental overriding theme that I've seen, at least, is this isn't right. We don't want this to happen to us. And how do we live in a country where this is okay?
Yeah, what kind of feedback are you getting? What kind of comments and stuff? I mean, everyone's got a comment on everything today.
It is. It's kind of scary when we were trending on Reddit, which was very interesting for me. I made the mistake of reading some of the comments, and some people are just so misinformed about it. And the first couple comments are, "Oh no, you could still sue them. They're wrong." I'm like, well, did you read the opinion? It said, no, we can't. We got to go to arbitration. So you deal with a lot of those, but it's a very small percentage. I would say about 95% of them have all been very positive, very sympathetic. I think they realize the severity of this accident for my client. She didn't want to, talk about it, but realized that, I really give her a lot of credit. It's not just about her. It truly is trying to change things for other people, because there is a very distinct chance that unless the Supreme Court takes this up, we are stuck with arbitration. And she knows that, and she wants to testify at Congress about this. I mean, and she knows that's not going to change her, situation. But if it prevents someone else from going through this, that's what her and her husband want to make sure they do. I admire them.
Arbitration can be really unfair for consumers, and we talked about a little bit about that before. But one of the other problems with arbitration is there's no appeal, So if the arbitrator just is 100% unfair, just got it wrong, just blatantly rules in favor of the company that gives them all this business, there's nothing you can do about it. The only way you can overdo an arbitration is if there's fraud,
right?
Which is next to impossible to prove in the arbitration context.
Yeah, so we're stuck. I mean, it's binding arbitration. We're stuck with the people they select, and we're stuck with their rules.
That's something too. I guess we kind of just glossed over it, but there's so many fail safes in the civil justice system. You go, you get a jury verdict. Someone appeals that, or say you get a bad decision at the trial court level, and you want to get it right. Well, there's an appellate division that can review that decision. Yeah. And if you don't feel like they get it right, then there's a higher court that can review that decision. It's all these different fail-safes that you just don't get with arbitration.
No, and when you look at different jury systems and judges in different states and everything, New Jersey has a pretty good system overall. It's not perfect, but it's pretty good. And the judges, as we talked about, they're vetted. They're not elected. They're truly, when we nominate someone to become a judge and they go through this process, hopefully the thought is that they've got, a lot of experience, they're the right temperament. And I think overall we've got some pretty good judges here in New Jersey. And so, by removing our case from these judges that have all these fail-safes and everything, if you have a problem, you can go up, you can appeal and all that, really it leaves the consumer at a huge disadvantage.
We talked about this a little before, but there's a whole kind of system set up and a whole body of like case law to protect people, to protect consumers, to prevent unfairness. Having corporations having too much power and kind of tyrannizing over people, and it seems like this battle in this country, that's been since its founding between the white landowning males were the first ones able to vote, and then there was suffrage and women's rights and the civil rights, and there's this ongoing kind of battle for kind of justice and equality. And as it's like the war in Ukraine, like drones, the first drone war, and like, oh, the drones are crushing it, and then they come up with a countermeasure. Now they can get the drones, and then it's like that with this stuff too, where you get laws and you get the development of society to make things fair, but then they come up with the next trick. Yeah. And the next trick that they're coming up with, because it's so easy, because everything is digital, is this click-wrap terms and conditions. And if people understood just how unfair it was, and really no one cares until the feces hits the fan, I'm trying to keep it PG here.
Or it happens to you.
Yeah, until it happens to you, and then you realize that, but it's really nothing new. There was a law passed in New Jersey, I think it was in the 80s, and it's called TCWNA. It's TCWNNA, something like that. But it's the Truth in Consumer Contracts Warranty and Notice Act. And basically it was passed because, someone would go into a store and they would have a sign that says, no refunds, or if your product breaks, you can't get your money back. Like, if you're injured by this product, you can't get, you have no rights. And they passed this law to say that if there's any terms and conditions in consumer contracts that take away people's rights, that they should be declared invalid as a matter of law, like that they don't apply. And I believe that was passed. I mean, you did a lot of work in that area, Mark. What was that law all about? Why was that passed?
Oh, yeah, because essentially, I guess, before what we have now, it would be the same thing. Companies would try and bury terms in contracts and agreements that weren't actually enforceable, but they would purport that they were, and people would,
But they were enforceable. It's just any terms and conditions that take away rights or violate a law,
or
right?
purport to take away those rights. So
Right.
say, for example, you buy a car, and it's like if you're involved in a crash because the car explodes and doesn't work properly, you're not allowed to come back to us for property damage or for anything like that. And they would have that clause in a contract or a purchase agreement, and that clause wouldn't necessarily be enforceable, but it would purport to be enforceable, and people would think that it was. And the idea was that these clauses would stop people from taking action that they otherwise would be allowed to take. And it was a very nuanced thing, and there was some case law that came out because there was a whole concept of whether or not you had to be an aggrieved consumer, whether or not you actually had to have suffered a harm as a result of these terms and conditions. And for a long time, the issue was open that you didn't even have to have suffered a harm, just have been exposed to or offered these terms and conditions, which the idea behind the statute, behind the law, I think was a great idea.
Yeah.
I think in the 80s, the legislature and consumer advocacy groups that were behind that law recognized the unfairness of this kind of thing. And we have the same thing here today. It's just in the digital realm, So maybe the legislature needs to update that to make it explicit that it applies to the digital realm, although I think it does apply anyway.
I agree. And I think what we kind of see happening here, and you see it a lot just in society, like technology will advance so quickly that regulations haven't caught up to it yet. The system of laws hasn't caught up to it yet. And a lot of people who sit in power, sit in the legislature, if you were to try and explain something like this, they'd be like, what? We're just not there yet. Yeah. And we need to get there. And it kind of takes cases like this to do it, because these click wrap things, like you're saying, nobody's reading them.
Yeah.
Like, it's great when a judge, like Judge Kaplan did, can go through and differentiate and say, hey, this is what's right, this is what's wrong, this is why this applies, this doesn't. But at the end of the day, these binding click wrap things, it's absurd. Like,
but I mean, you could literally have it in pretty much every facet of life. You go into the hospital and you're on the gurney and you're like, oh yeah, here, sign whatever. I mean, it could say, and you can't sue the hospital if they if they take your leg off, and they're not supposed to. And the legislature's gotten onto this. The people in Trenton that passed the laws for New Jersey, And in employment cases, law against discrimination cases, that's the other thing you could do. Like, you know, if you're in an office and there's like sexual harassment, and you say, you know, I'll give you a promotion if you give me sexual favors or something, you know, completely illegal. But okay, if you want to work here, you have to sign something that says if that happens, you can't do anything, or you can't bring a case for it, and you have to shut up. But the legislature saw how unfair that was and banned forced arbitration in the employment context, at least. You know, so.
Yeah, I think they realized, you know, that this is not a good thing, and so the legislature, they stepped up and did the right thing, and they've done that with a lot of sexual assault cases too, where they can't enforce the arbitration clause if there's an allegation of sexual assault. But, you know, sexual assault and, you know, the injury you suffer there is, you know, commensurate with these serious physical injuries that people are suffering, you know, in these car accidents too. So, you know, I don't see much of a difference there.
It becomes like, who do you choose to protect? You know, do you protect the public, the
David
consumer?
or Goliath.
Yeah, or is it this multi-billion-dollar, you know, industry?
You know, the old Ford Pinto, there's the old Ford Pinto memo, and Ford Pinto had these cars, and they put the gas tank in the back so that if you rear-ended the car, the Ford Pinto, it would blow up and explode, and there'd be death and destruction. And there was actually a memo, as I understand it, you know, from reading about it. They had a memo where they had like their analysis people or their engineers say, okay, this is what it will cost to retrofit and fix all the millions of Ford Pintos that are out there and move the tank to the middle of the car. And then they had on the other side of the column, they said, and this is the amount of people that will probably die, and this is what we'll probably have to pay. And because the total amount to make the car safe was more than the amount to pay out on the death claims. Like there was the famous Ford Pinto memo, and I think they chose the former, which was let's leave it the way it is, or the latter, let's leave it the way it is.
Less for them, less for them to pay out.
So here's the thing:
it's not just a John Grisham novel. I mean, that's what you would. This is real life stuff.
Yeah. So that's the thing here. So like, if your Uber driver has a history of you know sexual assault or can't see all that well, so that he or she has to go 45 miles an hour on the New Jersey Turnpike because he can't see, and there's a crash and burn, and we can pay like a little bit of money. You know, we got 7 severely injured people, and we can get out of that for $1.5 million. You know, that's going to be a lot cheaper than training and hiring proper drivers and maybe paying the drivers a little bit more of the percentage that you actually pay on the app. So if this forced arbitration gets forced, then there's going to be no incentive to change. Right. And then the next driver is going to go through a stop sign like it did here, the red light, and maim and kill people. And you know, because I'm sort of on a soapbox, but I guess that's part of the purpose of the podcast. You know, there's no disincentive for any of that stuff. Yeah. That's a problem.
And what you talked about, the Ford Pinto case and the balance of to pay this out versus to pay out at about that because there was a public litigation. Yep. There was litigation that was filed. Imagine if those Ford Pinto cases that had mandatory arbitration provisions where someone files that case, their family was engulfed in flame, from a crash. You'd never hear about it. We'd be sitting here coming up with some different example of trying to think of something else.
Yeah. And I think that's why the legislator really does need to step up here to do something about this and create a legislative fix. I think that's definitely the best way to address this. We have a new composition of the Supreme Court here in New Jersey. We have a lot of new jurists. One of the most pro-consumer jurists, has retired, who was a guest on your podcast, Justice Alvin, who was great on consumer rights, and, he's retired. So I don't know how this new court is going to handle this issue, and that's why, I think the legislative fix is really what these lawmakers need to do to make it safer for people here in New Jersey.
Yeah, but it sounds like here that there was some real, concrete and discrete legal issues that the Supreme Court should take a look at.
Yeah,
I don't think in the McGinty case it's one where you would just kind of wash your hands and say, it's up to the legislature. I think there's more to it than that, because really they weren't interpreting any statute here anyway.
No, and again, they have stayed the litigation for everyone here. And going back, there's a couple other things that the appellate division did not really address, and that's one, which is, the information that Uber says they have that proves that my client clicked this, like, we don't have access to that. And that's like a fundamental unfairness. Like, where nobody wants that. Like, where can you make an allegation but not support the allegation? Through discovery.
In arbitration.
Yeah, in arbitration, exactly. That's
How
the only
old
place
was
you
the
can do
daughter
it.
that allegedly?
12 years old.
Yeah, I mean, I always learned in law school that if you're under 18, it's the famous scene from Liar Liar when she lied. What was it? She did the prenuptial agreement.
Yeah, but she was 17.
But she was
Yep,
16
yep,
or 17.
yeah. Spoiler alert if you haven't
Everyone's
seen
seen that movie.
Yeah.
And so because she signed the prenuptial agreement when she was under 18, it didn't apply. So how on earth can a 12-year-old bind parents by clicking and ordering food? I mean, what's happened to our society where that's a thing?
And like, we're entitled to this information. Like, when somebody makes an allegation or a defense like that, like, you should be able to depose them like you do. And like, that's standard. Every lawyer who's listening to this, even if you're not a lawyer, you probably understand that's probably what happens. You just don't have to accept what they say is true. They've got to prove it.
So Uber signed like a sworn statement saying she clicked on it at this hour, at this time. And it was just, and your investigation shows that that's kind of like a boilerplate thing, that they use the same kind of affidavit in many cases.
And so that was a surprise to us, because we got the certification. They says this is the exact representation of what your client signed at this time.
Yeah.
And then we got another case where it was the same graphic, and I was like, this is unusual. Like, it's the same time for both of them, two different cases. Like, this doesn't make sense.
Yeah, that sounds a bit unusual, because in a normal litigation, if they presented something like that, you would have the opportunity to take the deposition of the person that signed the affidavit, get all the supporting documentation, maybe look at some computer forensic information to see if it was real or not.
Yep.
I mean, geez, with AI today and so many things being faked.
And Photoshop, I mean, it's a document. It's in the public record. Everyone can go look at it. And it's the same certification they're filing on every one of these cases, which raises a lot of concern. So, candidly, I was, one, surprised by the appellate division, but also disappointed because they didn't realize that issue where they've already assumed that this stuff has been validated. And we never agreed to that. We never said that that's what happened.
We go ahead.
No, I'm just sitting here. You're probably going to go different. So I'm sitting here thinking through like different hypotheticals and things like that. So it's like, imagine someone goes to a bar, gets drunk drives home and slams into you, T-bones you, and you have, hold on. Yeah, and you get slammed into. You get your day in court for that case. But if somebody decides, all right, I'm going to take an Uber home instead, and then slams into you, and you happen to have an Uber account, you're not getting your day in court. You're going straight to arbitration.
Well, so Uber right now is, if you're in the Uber and you've agreed to the terms and conditions, they are going to, they have the right to assert the arbitration clause. What I'm afraid of going forward is, what if I'm driving and there's another Uber driver, but I have my own Uber account, but I'm not in an Uber? Like, is that where they're going, where they're going to try to enforce the terms and conditions, even though I'm not even in the Uber? Because they've done that with some other cases where people happen to be a beneficiary of the ride. Their friend selects the Uber, but they have their own Uber account, and they previously have agreed to terms and conditions. So they didn't even agree for this ride, but sometime in the past they did. So, people that have an Uber account that they've agreed to these terms and conditions, they get involved in an accident, not related to that Uber account, but, they happen to be driving. They could be walking in front of a car and, whatever. And so it's crazy to think that they can enforce that.
Yeah, and what people should know too is like, arbitration doesn't sound so bad, but in these same documents, this click wrap, the arbitration clause is that's just the tip of the iceberg.
Yeah,
in many of these consumer contracts, if you bring a case or you bring a claim and you lose, you have to pay all their attorney's fees. There'll be provisions in these consumer contracts. I've seen them, whether it's a shopping company or buying a boat or anything like shopping, or an alarm company, where if anything happens, if there's any kind of litigation anywhere, that you have to defend and indemnify the big company, which means you have to hire lawyers for them and pay their legal fees and pay any judgment for them. or to get fairness, if anything happens, whether you're killed, maimed, if you're ripped off or scammed or your computer's hacked and you lose your credit and your identity theft. Okay, well, you have to bring the case in Fairbanks, Alaska.
Yeah.
And you have to bring it within 3 months. And if you don't bring it in 3 months, you don't have a case.
And the laws of Alaska apply.
I mean, just look at the click wrap, like, with internet companies where we can listen into your conversations, we can take your personal information, we can market to you. The Constitution generally, like the freedoms we have, generally apply against the government. It's the government intrusion and government rights to privacy. But a lot of times these kind of the corporations can like exercise tyranny over people even more. I mean, it's just, things can be so unfair.
Yeah, it just seems, and again, your case, it seems absolutely is an issue of public importance. I think Jerry's right. On the legal merits, there's plenty of issues. I kind of joked that it's like a law school fact pattern, but there certainly are a number of legal issues, and I thought Judge Kaplan went through and identified, many of them. But it does become like, where do these click wrap agreements stop?
Well, let's talk about other states too, because we live here in New Jersey, where we got this terrible decision. In Pennsylvania right now, that's the other way, where Pennsylvania said, "Oh, this language is unconscionable," and there was a recent decision that came out that said, "Oh, trial by jury, you can't do this. This is insane." But New Jersey
take away the trial.
Exactly, yeah.
And they probably follow the
Jersey,
FAA.
Yeah,
too.
and so New York has, I think next week they're deciding a very similar case. So it truly is affecting everyone everywhere. And it's just fundamentally unfair that on one side of the Delaware, it's one side, and then on this side, it's the other.
Is it a red state, blue state thing? I mean, not to go into that kind of thing, but like, do we find
Get flagged? We'll get
we're
flagged.
flagged. Do we find things like in Texas? Or it's kind of funny. It's not. Some red states will be more pro-consumer, more. Like they get big jury verdicts in Alabama or something. Like, what are you seeing in this context?
So I think generally, big businesses are, more red state, I think, and they have better protections there. And so I think you see more arbitration enforcement there. That's what's kind of doesn't make sense about this here in New Jersey, because I, before this, really thought New Jersey was more pro-consumer. We've got great Consumer Fraud Act here in New Jersey, which other states don't have. Pennsylvania doesn't have the same Consumer Fraud Act that we do. Attorney's fees and costs, treble damages, that really, it helps. That knocks down on consumer fraud because we have significant sanctions that the state has provided us to go after people who do that. So that's why I was surprised that New Jersey, which is, I guess we're more purple now, I don't know, but it just seems like this is very anti-consumer.
Yeah. We have awesome courts. I think Jersey has the best courts in the country. But, I've seen, it's kind of funny, like we have a case, I just argued it in front of the Supreme Court, and the Appellate Division, they got an issue just like completely wrong, because everyone makes mistakes and stuff, and I think the Appellate Court, the interim, so in Jersey we have the trial court, which is the lowest level, then we have the middle level, which is the appellate, and then we have the Supreme Court. And as I understand it, the middle court has the biggest caseload, and they only have like limited judges.
Wow.
So they don't always get everything right. And then we have this thing called these unpublished opinions. Just so people know, like the law is, the quote-unquote case law is what's actually put in the books, and it's on shelves, and it's reported. That's why we say reported or unreported, or published and unpublished. And the published cases are the ones that actually set the law that you can cite to. But we also have these unpublished cases where you can also cite to them, but they're not as persuasive as the other. And it's crazy because I almost call it sometimes like bizarro law. Like you have, back in the day, we had the Super Friends. They were the good Super Friends, the superheroes. But then you had the bizarro Super Friend, which like, so you had the regular Superman, and then you had bizarro Superman, who had this like ruddy complexion and just looked meaner, but he had the same cape and blue suit with the S on his chest. And sometimes I feel like these unpublished cases is like the bizarro law, because I've seen so many things where I know exactly what the law says, the exact published law says, and then you'll get decisions from the Appellate Division that are unpublished that go exactly opposite to that. So sometimes it can be workload issue or something, or I don't know.
Well, and interestingly, during the pandemic, there were not as many appeals because there weren't any jury trials at the time. So really, the appellate division caught up, I think, and so we were getting decisions a lot faster during COVID because there weren't any cases up on appeal as much, and so I think that the judicial shortage has definitely affected the appellate division. And, we all, as trial attorneys, we all know that there are many counties here in New Jersey where we don't have enough judges due to the political process and other outstanding issues. And so I think that has definitely hurt the appellate division. So.
That's cool.
I don't know. I just keep going back. There's just got to be a line somewhere. And obviously, the facts of your case, I hope the Supreme Court does take it. Yeah. I can't sit here and tell them that they should, but I hope that they would.
We've had a number of groups reach out to us that say if the Supreme Court does grant certification, which is their willingness to hear this, that they want to serve as amicus counsel, which is a friend of the court. And so even though they don't have a horse in the game, so to say, they're not a party to the litigation, the issue is of public importance to them and their group and their specialty group, and so they would like to participate in brief as well and have an opportunity to talk to the Supreme Court about that. And so, the Supreme Court, the parties have more time to argue, and typically amicus, they're granted about 5 minutes or so, but they have the ability to brief and everything too. And that's really a great part of, New Jersey as well, is our, ability to do that through the amicus process. And so hopefully if we do get the certification granted, there are a number of groups that have reached out that are very interested in helping with this very important issue.
Yeah, they call them amicus curiae, which I'm assuming is a Latin term for friend of the court. And the law says that the amicus is not supposed to be an advocate. They're not supposed to favor one side or the other, but actually they do,
Right.
So you'll have an amicus for the one side, for the defense, then sometimes you'll have amicus for the plaintiffs. In the case I had in front of the Supreme Court a couple weeks ago, we had the defense, the insurance company had amicus counsel, and it was just us. Like, we didn't have amicus counsel. It's kind of like tactical air support, in war. And at least that oral argument, it seemed like the insurance amicus counsel was engaging in friendly fire. Like, they actually helped us, which was good. The amicus counsel was good. The court was super. I love arguing in front of the Supreme Court because they're really good lawyers and they're super smart. And it's cool. It's kind of like, like if you play basketball, you play pickup basketball, the guys aren't as good. You play kind of down to that level. If you play like with better guys, you'll just sort of like play better.
Yeah.
And it's a good feeling to play up, so to speak, in baseball or something. And arguing in front of the Supreme Court, it's like you're playing up, and it's pretty cool.
Yeah.
And they asked the amicus counsel these pointed questions, and he couldn't lie to them. And he had to be like, yeah, well, this is what it's got to be. I mean, that's what it is. And at least that oral argument, knock on wood, I think it helped our side. And
New Jersey really has a wonderful precedent and tradition when it comes to the Supreme Court, where the governor doesn't just necessarily appoint his people.
Sure. Yes.
They try to make it fair. And, Governor Murphy, has not just appointed all Democrats to the Supreme Court.
Yeah.
He's followed that tradition, which I think is very important for the court and also for people to respect the court.
Yeah.
It's not just one side. It truly, they want to be diverse. They want to have both sides, and they want to get to the right decision.
Yeah, it's good too, because our Supreme Court justices also are not permitted to take vacations or get on private jets funded by the attorneys that argue cases before them. So that's a plus too.
Yeah, take
Huge
concert
plus.
tickets.
Yes.
That's funny.
Yeah.
All right, unless you got anything else.
No, thank you so
That
much,
was
gentlemen. Hopefully, I'll let you guys know in a couple weeks if we get certification, and I know that's the next step. So
Yeah, we appreciate what you do. We appreciate what you do on behalf of consumers and fighting the good fight on behalf of regular people. So if people want to get in touch with you or whatever, how can they find you? What is it, 2024? So they can type in Evan Lide.
that's right. Just
on
Google me;
Google.
it goes right there. Go to our website, stark-stark.com. I've got a big site there, and just remember, be careful what you agree to, and read the fine print very carefully, because you don't want to be in this position.
Yeah, awesome. Thanks again.
Yeah,
I really
thank you,
appreciate
Evan.
you doing this.
Thanks,
Big
gentlemen.
time. Yep.